Uama Keʻeaumoku I ka pono o Hawaiian Uama Keʻeaumoku I ka pono o Hawaii.
Aloha ahi ahi kako, and welcome again to another episode of Kanaka Express. Mahalo for welcoming me into your home tonight. And this is a Hanaho show that we have as a result of the show that we had 2 weeks ago with Dr. Keanu and Attorney General Dexter Kaʻiama. And we're going to be talking about the federal case that is ongoing in Honolulu, and adding more information to you so that we can share that with you. And I'm very excited about this because there's been a lot of you that have sent in questions and wanting to know more, and so we're going to try to address those questions tonight and get you some answers. So I'd like to invite my co-host Keʻeaumoku to come and join me, and he's one of my favorite kumus at Kamehameha School, East Hawaii campus, and not one, he's the only favorite kumu that I have at Kamehameha schools. Welcome, Keʻeaumoku.
Hello, Mike Ako, Nahoa Makamaka. Welcome back. Super excited to be talking about the court case again and learning a little bit more. I think about all the time, it's not just understanding if we win or lose, but really understanding that the information is getting out there, is being part of public record, and the more and more that we chomp away at this occupation, the more truth comes out. And so exciting to be able to talk started tonight, to learn more and to have our viewers, be able to ask some questions and be able to get some understanding. So now's the time, get ready, hook up. So I put in those questions inside of the Facebook chat box, and here we go.
Yeah, and please, again, you brought up something really good. Please, if you have the questions, put them in the chat box on Facebook so that we can try to get that addressed tonight. If we don't get it addressed, we will address it down the road to you, whether it's by text or maybe even having another show on this. But it is very important because this is a whole learning process as people are trying to understand it and trying to get a grip on it, and so it's not easy. But at the same time, if all of you hang in there, we will all learn about this and the significance of this court case. So what I'd like to do is, again, my two guests, we have Dr. Keanu from the Council of Regency, and the Attorney General for the Hawaiian Kingdom, Dexter Kaʻiama. Welcome.
Aloha, welcome.
Aloha. Yeah, aloha ai kako.
I think one of the questions that I'm seeing all the time is people are asking, what is there have been many court cases throughout the years with Hawaiian activists going to court and so forth. Primarily, this was all in state court. And what is the significance of this case that was filed with the federal courts that the Hawaiian Kingdom did against Joe Biden? What is the significance?
Okay, Keanu, if I can, I'll start. Yeah. So, again, Dexter Keʻeaumoku Kaʻiama. I'm the acting Attorney General for the Hawaiian Kingdom. And it is in my role as the acting Attorney General, of course, I'm advocating for the end of the illegal prolonged occupation of the Hawaiian Kingdom by the United States, and specifically addressed in this case, the Hawaiian Kingdom versus Joseph Robinette Biden Jr. et al. For the U.S. District Court of Hawaii's transformation under international law into an Article II court, as well as and we'll explain later with the filing of our notice of appeal, demands that the U.S. appellate court or the appellate court that should hear this case should also be a court of competent jurisdiction, meaning an Article 2 court as well. So I think that explains, Kali, and perhaps maybe answers your question as to the larger goal of the proceedings, as well as the specific goal, which is to demand or actually force or perhaps create the transformation of these courts into Article 2 courts under law.
So what for people? How is this going to affect them? For the people that live here in Hawaiian.
You want to answer, or shall I just continue with the answer, Keanu? Dr. Sai.
Let me throw a little bit in right here with regard to everybody. So, as Dexter stated, the purpose of the complaint is to address the prolonged occupation of Hawaii. The ultimate goal would be to end the occupation, but preliminarily, we're looking at bringing compliance to the law of occupation, which is to administer the laws of the occupied state. That's a provision of international humanitarian law that is under Article 43 of the Hague Regulations and Article 64 of the Geneva Conventions. Some people think, well, in Hawaii, we need to have our own government to administer the laws. No, not during occupations. It's the entity that is in effective control of territory that has the obligation to administer the laws of the occupied state. What the Council of Regency is doing and has been doing, its grand strategy, is how do you bring compliance to those particular rules? Now, in order to get the court to issue an order basically transforming the state of Hawaii and the counties into an occupying government, recognizable under international law, not as an American entity created by American law in a foreign country, but a recognizable entity under international law. Before we can ask the court in our relief trying to get that order to be issued, we needed the court to transform itself into an Article 2 court, and that's why Dexter was addressing that issue of the court's jurisdiction. And that court's jurisdiction is crucial because when we filed the case, the Hawaiian Kingdom filed the case, the Council of Regency, it was not seeking the court to recognize the Hawaiian Kingdom. The Hawaiian Kingdom's existence is a presumption, meaning it exists. We have a lot of evidence already, which includes primarily the Permanent Court of Arbitration already acknowledged the continuity of the Hawaiian Kingdom, meaning they could not deny that. And that's why they acknowledged the Hawaiian Kingdom as a state. We're not asking the federal court to do that. We're asking the federal court to grant relief because of all these years of not complying with the law of occupation. Get the United States, which is the state of Hawaii and its counties, to transform itself into an occupying power, to administer the laws of the occupied state. We're looking at this court. We did look at this court as a means by which to enforce that rule. Okay. And that's where we're at right now. So let me turn it back over to Dexter to maybe add a bit more procedurally of what we're talking about, and lately with the notice of appeal and the significance of that notice of appeal, where I can add more analysis. Dex.
And just to, before I move on to that, just to add, the transformation of these courts into Article 2 courts would be significant compliance with international humanitarian law. And part of that transition, that next step, or at least another step increment in the administration of Hawaiian Kingdom law in the territory of Hawaii. That being said, let me just go ahead and move on to the next part, which is kind of a procedural matter. As your viewers may know, or may not know, that on April 24th of this year, April 24, 2022, the Hawaiian Kingdom filed its notice of appeal from the U.S. District Court of Hawaii, Judge Kobayashi, her two orders, the first order granting in part and denying in part, Norvell, who's the honorary consul to Sweden for Hawaii, Norvell's motion to dismiss the amended complaint against him, as well as the Hawaiian Kingdom's motion for the court to take judicial notice of, as we explained earlier, the juridical act of the existence of the Hawaiian Kingdom and the juridical consequences as well. Before I move on to that, I actually wanted to read to you from our notice of appeal a part that was added, found by Dr. Sai, that we added to the notice of appeal at the very end of the notice of appeal. And this is a Supreme Court decision from the Hawaiian Kingdom Supreme Court. And that is in Shillaber versus Waldo, 1 Hawaii 31, and this is in 1848, where Chief Justice William Lee stated, "In the language of another, let justice be done, though the heavens may fall. Let the laws be obeyed, though it ruin every judicial and executive officer in the kingdom courts. In the kingdom, courts may err, clerks may err, marshals may err. They do err in every land daily. But when they err, let them correct their errors without consulting pride, expediency, or any other consequences." So that is the nexus or the gist of our appeal in this case. We believe the court, of course, it is our assertion that the court did err in granting Norvell's motion to dismiss, as well as denying the Hawaiian Kingdom's motion, request for judicial notice. We also assert that the court erred when we filed our motion to alter or amend the court's orders previously, the Norvell order and the judicial notice orders, and when the court denied by minute order our motion to alter or amend. And that was important, and we laid that out because it was important for us to let the court know that there is a Hawaii Supreme Court decision that addresses the court's error and the court's, obligation to correct its error. So if I may, let me just talk about it. Oh, in our notice of appeal, we appealed again to the U.S. District Court for the Ninth Circuit. And in there, we basically informed the Ninth Circuit Court that we are preserving the record of the proceedings in Hawaiian Kingdom versus Biden until such time that a competent court can be it can be established under Hawaiian Kingdom law and international humanitarian law. And that is, again, as we discussed earlier, a competent appellate court transformed into an Article II appellate court. We asserted that until such time, there really is no court that can address and grant the relief that we are requesting in our complaint. Nevertheless, we filed the notice of appeal in order to preserve our record. For your information, and it is pending, the appeal is pending, we've received communications from the appellate court, which requires us to meet certain court requirements in order to continue with the appeal. And Dr. Sai may speak to it more. We will continue to proceed with the appeal under the, under the caution that only a court of competent jurisdiction, that means an Article II appellate court, can address our claims and grant us the relief. By doing this, we're of course saying so that we will not be submitting ourselves to the jurisdiction of an Article II court, which is presently the court that is in existence in the Ninth Circuit. Because that court, again, is a court that is in violation of Hawaiian Kingdom and international law and is unable to grant the relief and address the requests and our claims. Let's see. I think, I guess tonight's discussions, we're going to be talking about largely dedicated to the Norvell and Hawaiian Kingdom request for judicial notice, the orders that concerning those two cases, those two matters, Hawaiian Kingdom's motion to alter and amend, and then the court's minute order denying the Hawaiian Kingdom's motion to amend, and finally the notice of appeal. Just wanted to let you know that I'm going to be letting Dr. Sai speak more to the analysis and the rationale of both the Hawaiian Kingdom's pleading as well as the court's, its reflection on the court's orders. And I'm going to be sticking more to the procedural matters for a number of reasons. One, because as the advocate for the Hawaiian Kingdom, and because the notice of appeal is pending, I guess I wish to refrain from making comments as to the rationale for the court's decision until such time as the pleadings have been filed. And also because, of course, Dr. Sai is, as we say, he's our expert witness, and he can speak, I think, probably more eloquently as to the court's rationale, or supposed court's rationale for its orders. So, if I may, let me just start with the Hawaiian Kingdom's motion to alter or amend. As we know previously, the court did grant, in part, Norvell's motion to dismiss, and did deny Hawaiian Kingdom's motion for judicial notice. So our motion to alter or amend was addressed in 5 parts: our introduction, the statement of the case, standard of review, argument, and then the conclusion. So in the introduction for our viewers, the Hawaiian Kingdom informed the court that it moves to alter or amend both the Norvell and the request for judicial notice orders. Excuse me. Let me slow down a little bit. Because first, the court's announced decision in both orders that the Hawaiian Kingdom does not exist as a state, without providing any facts or conclusions of law supporting its reasoning. And second, of the Hawaiian Kingdom's request for the court to reopen the case for the purpose of adjudicating the Hawaiian Kingdom's standing as a sovereign and independent state in continuity since the 19th century, by having the court provide findings of facts and conclusions of law that provides a rebuttable presumption to the presumption of continuity of the Hawaiian Kingdom as a sovereign and independent state. And as I continue, if at any point, Dr. Sai, you wish to step in and provide comment, I'll just go ahead and do that, and then I can continue.
Okay. Let me just kind of touch on a few things here. Okay, so in this particular case, when it was filed, we're moving to secure an order, as I stated earlier, but the judge cannot issue that order compelling the state of Hawaii to transform itself until it's an Article 2 court. So for the past 11 months, that has been that 800-pound gorilla in the room, the existence of the Hawaiian Kingdom, which would automatically trigger the court to transform itself into an Article 2 court. And an Article 2 court would be a court coming under the president's authority as commander-in-chief of the military in foreign countries. Okay, so an Article 2 court was established in Germany from 1945 to 1955. And that Article 2 court in Germany was administering German law and the law of occupation, because German courts at that time were not fully operational. A lot of them were, but not all. So the Article 2 court was established to augment that. Okay. So when we applied or filed the complaint, that was what we were seeking, was an order to compel the state of Hawaii to transform itself. Now, when the issue became the Hawaiian Kingdom, we did not file the case in order for the court to declare the kingdom exists. In fact, we were forcing the issue for the court to declare that the Hawaiian Kingdom doesn't exist. But as it doesn't exist, it has to provide evidence. So we had this understanding before the case was filed. Okay. And the presumption of the Hawaiian Kingdom's existence is a crucial legal rule in a court of law. And that's where the presumption rule kicks in, is in a court of law. The presumption does not kick in on a platform of debating an issue, right? A presumption is very important to understand. And that presumption means that under international law, there is a presumption that that a country as a state continues to exist despite its government being overthrown, right? Because the only way that you can acquire a country, not a government, how you acquire a country after the government was overthrown, you need a treaty. And that treaty would be the evidence by which a state transferred itself and merged with another state. In this case, the Hawaiian Kingdom transferred itself and merged with the United States. You need a treaty. We don't have a treaty. There never has been a treaty. Okay. So that means that without a treaty, the presumption of continuity remains. Now that puts the burden on the opposing side to show evidence that the Hawaiian Kingdom was extinguished. You can't make a statement the Hawaiian Kingdom does not exist. You can't say that in a court of law. You can say that on a political platform and scream all you want, right? And get people to believe you. But in a court of law, that presumption rule is significant. Okay. So that is important to understand here. So when we are going to be responding to the actions taken by the court, whether it's Judge Kobayashi or Magistrate Judge Round Trader, it has to be within that framework of the Hawaiian Kingdom's continued existence until either Round Trader or the district court judge provides evidence that the Hawaiian Kingdom has in fact been extinguished. Okay. Now, when Judge Kobayashi, after 11 months of this case, she wanted to poke the gorilla. And she made in her statement with regard to granting partially the motion to dismiss of Nerval, who is the honorary consul of Sweden assigned to Hawaii. She stated specifically there that plaintiff alleges that the article that this court cannot address the motion submitted by Nerval until it transforms itself into an Article 2 court. So that clearly shows the judge knows that, meaning that's been a part of the pleadings. This is not something new. It's been ongoing for 11 months. Now, the point though, she said, she then made a terse statement that there is no factual legal basis for the Hawaiian Kingdom's existence as a state, as stated by a federal court in Honolulu in another case. And therefore, because of that, she can address Nerval's motion. So it was directly tied to her taking the position that the Hawaiian Kingdom doesn't exist, therefore she doesn't have to transform herself into an Article 2 court. She can remain an Article 3 court. Now, she also made that same terse statement without any evidence that the Hawaiian Kingdom doesn't exist, therefore there is no need to take judicial notice that we requested of the actions taken by the Permanent Court of Arbitration, which is their juridical act in creating the the juridical act of acknowledging the Hawaiian Kingdom as an independent state for jurisdictional purposes. Okay. So at the Permanent Court of Arbitration, the Permanent Court did not hold a hearing to determine whether the Hawaiian Kingdom continues to exist. All they did was look as to the evidence, because of the presumption rule, look at any evidence that would rebut the presumption of continuity of the Hawaiian Kingdom's existence. So they had to find evidence to show that the Hawaiian Kingdom did not exist or does not exist, at least at that stage when it was before the Permanent Court of Arbitration. Because they couldn't find any evidence called a treaty, all you had are American laws being imposed in Hawaii, which is a violation of the sovereignty of the Hawaiian Kingdom, as it would be for any other country, for an imposition of laws. That imposition of the imposition of American laws is not rebuttable evidence that would rebut the presumption of continuity. So I'm trying to break this down for people to understand out there. I'm trying to break it down in a simple way, right? The importance here is not whether or not the Hawaiian Kingdom exists. The presumption already says it exists. The question is whether an opposing party can provide evidence that the Hawaiian Kingdom does not exist. And that's important. So when Judge Kobayashi made those statements that the Hawaiian Kingdom does not exist, that doesn't work in a court of law. It may work in a court of rhetoric. It may work in a court of politics, but it does not work in a court of law. And what we basically did was we brought to task upon Judge Kobayashi. You made the statement, okay, follow up with the evidence. So when that was placed upon her, we also had to explain, as Dexter stated, in our motion to reconsider her decision in these two orders, you have to adjust your decision in light of the presumption of continuity, which we fully explained, right? Now, what's important here, what's important is in the Paquet Habana Supreme Court case in the early 1900s, I believe it was 1905, if I'm not mistaken. In that case, it said international law is a part of American federal courts, and it must be applied, especially if a party relies on international law for a particular invoking of a right. Well, international law says that there is a presumption of continuity, not American law, international law. So in our motion to reconsider, we had to ensure that we invoked the Supreme Court decision in Paquet Habana, that we are using their decision as the basis for us now bringing in the international rule of the presumption of continuity. We stated presumption of continuity in the complaint. We made constant reference to the presumption, but it was the motion for reconsideration that we elaborated on that presumption of continuity, clearly making it a part of the record. And that's what's important. Right? So Dex, then turn it back over to you if you have anything else to add.
Yeah, and if I might, Paquet Habana was 1900, the decision, and specifically the holding of the court that's applicable to our case is Paquet Habana. The Supreme Court said international law is part of our law and must be ascertained and administered by the courts of justice of appropriate jurisdiction as often as questions of right depending upon it are duly presented for their determination. So, as Dr. Sais said earlier, given that context, that broader context by Dr. Sai, it's important to note that the court in its terse statement basically said that the Kingdom of Hawaii does not exist as a state. It relied on the case. In this case, it relied on the case of, sorry about that. Hold on one second. But essentially relied on State v. French. What the court forgot or actually omitted from its reliance on State v. French is that State v. French also relied on the original case, which is State of Hawaii versus Lorenzo. And in State of Hawaii versus Lorenzo, the court omitted the word presently. And now this is a smaller part of the argument, but it's still, we are pointing out one of the court's error. In omitting the word presently, the court, again, made took a stand or took a position as to the existence of the Hawaiian Kingdom, saying it doesn't exist. Again, as Dr. Sai said, without providing any evidence to the contrary. Any rebuttable evidence that the Hawaiian Kingdom had been extinguished. But Lorenzo, by using the word presently, said at that time, in that case, the defendant in that case, who had the burden of proving, did not provide evidence that factual or legal evidence that the Hawaiian Kingdom did exist. Now, what's important about State of Hawaii versus Lorenzo, as Dr. Sai stated, is that Lorenzo goes on to say that its rationale and its decision may be subject to, is open to question in light of international law. And that's where Dr. Sai spoke about Paget Habana and the reliance of international law, and then going to the presumption of continuity of the Hawaiian Kingdom. So essentially, we're pointing out to the court in our motion that international humanitarian law, Hawaiian Kingdom law, and Lorenzo itself shifts the burden to the United States to overcome the presumption of continuity of the Hawaiian Kingdom. A smaller part of it, another part of our motion to alter or amend, we pointed out to the court one of its errors in that, sorry about that, addressing the Norvell motion, where Norvell asserted that the Hawaiian Kingdom's claim against Norvell in his official capacity as an honorary consul to Sweden to Hawaii. And as such, the court does not possess jurisdiction over him pursuant to the Vienna Convention. When in fact, the Hawaiian Kingdom's claim against Norvell was that he held an incoherent or imperfectly formed title as honorary consul because he did not receive his exequatur from the Hawaiian Foreign Ministry by virtue of Article 12 of the 1852 Hawaiian-Swedish Treaty. Therefore, without accreditation by the Hawaiian Kingdom, Norvell cannot claim any official capacity under the Vienna Convention. And furthermore, Norvell provided no evidence that the 1852 treaty was replaced by the 1793 U.S.-Swedish Treaty. Accordingly, Hawaiian Kingdom has not been freely heard on this matter. So that's another area that we pointed out to the court. Following up on Keanu's his comments a few moments ago, in the order, in our argument, we again spoke about the presumption of continuity under international law and the court's obligation or any party opposing the Hawaiian Kingdom's continued existence as a sovereign and independent nation, their burden to provide evidence to rebut the presumption of continuity. Continuity. Again, we pointed out to the court that there hasn't been no such provision. No one has provided that evidence, neither the court nor any of the parties. In fact, the only evidence that was provided was by the Hawaiian Kingdom, showing a further confirmation and acknowledgement, actual acknowledgement of the continued existence of the Hawaiian Kingdom. We also made argument that the court's orders, the Norvell order, as well as the order denying the motion for judicial notice, was in violation of the separation of powers doctrine, the U.S. separations of powers doctrine, and that the court's declaratory position that the Hawaiian Kingdom does not exist as a state is an invasion into the powers of the executive branch, which the court is prohibited and without authority under the doctrine. Finally, with our closing argument on that, we asked the court to alter or amend the Norvell and request for judicial notice orders, and instead provide findings of facts and conclusions of law that provides rebuttable evidence as to the presumption of the continuity of the Hawaiian Kingdom as a state under international law, thereby correcting a clear error of law and preventing manifest injustice. So I will now turn it over to Keanu to provide any additional comments or analysis on that.
Okay, on that, I do have a question coming in from Daryl Pakele, and Daryl is asking that where is it that Judge Kobayashi admitted that the Hawaiian Kingdom exists in her order?
Okay, I can answer that. In fact, that's what I was going to get right into with Dexter when he passed it over. Okay, so let me go back to the presumption and how it works again, okay? But what I need to do first, though, is I need to take it where the court cited, because in all these cases before federal courts and state courts, the standard as to whether or not the Hawaiian Kingdom exists as a state it goes back to a 1994 Intermediate Court of Appeals decision called State of Hawaii versus Lorenzo. That, since 1994, that case has been cited multiple times, I would say hundreds of times, by courts denying assertions made by defendants with regard to the Hawaiian Kingdom's existence. It also ventured into other crazy stuff, right, in different areas. But they always use State v. Lorenzo. Now, when Judge Kobayashi cited State of Hawaii versus French in a federal case, right, a Fonoti case, when she cited State of Hawaii versus French, State of Hawaii versus French is also an Intermediate Court of Appeals decision in 1994 that came on the heels of State of Hawaii versus Lorenzo. It came right after. And in that State of Hawaii versus French, it said that the defendant, although this person believes generally in what they believe, they presented no evidence that the Hawaiian Kingdom continues to exist as a state. Therefore, they said, presently, there is no factual or legal basis for concluding the Hawaiian Kingdom exists as told and set by State of Hawaii versus Lorenzo. So Judge Kobayashi used specifically State of Hawaii versus French in her order, which had a direct tie to State of Hawaii versus Lorenzo. Now, I know State of Hawaii versus Lorenzo quite well. In fact, it was part of my doctoral dissertation. And Judge Walter Heen, who was the author of that decision at the appellate court, actually, he was reviewing my doctoral dissertation. And I asked him back in 2009 at a meeting that we had at Zippy's, I said, Judge Heen, if the appellate attorney, okay, the attorney representing Lorenzo in the appeal, provided you my doctoral dissertation that explains why the Hawaiian Kingdom exists, what would you have done? And he told me straight up, I would have granted the appeal and overturned the lower court's decision. He said that he didn't understand or understand to distinguish between the government, which was overthrown in 1893, as opposed to the Hawaiian Kingdom as a state that still exists under international law. So what we have there is, here's the appellate judge who wrote the opinion acknowledging that the Hawaiian Kingdom exists. It's just the attorney didn't present it. So I shared with Judge Heen, I said, we're going to start working on this because Judge Heen, you opened the door in 1994 and it's been used as a precedent case all the way up until 2009, which is that meeting I had. And I'll be working with attorneys to present these arguments. And he smiled at me. He said, well, that's going to get interesting. I said, yeah, it is. So what State of Hawaii versus Lorenzo says is that it is incumbent upon the defendant to present a factual or legal basis that the Hawaiian Kingdom exists as a state, despite its government being overthrown in 1893. Okay. Now, when the court said it is the defendant that must provide the evidence, right? It also stated in their decision that their rationale, which Dexter referred to earlier, that the rationale of the court in making that statement that the defendant has the burden is open to question in light of international law. So then what does international law says with regard to a state despite its government being overthrown? And international law says there's a presumption of continuity. So that presumption of continuity, okay, that presumption of continuity means that the Hawaiian Kingdom still exists as a state until the opposing side, in this case, the prosecution of Lorenzo, provides evidence that it doesn't exist, not that Lorenzo has to prove that it does exist, right? Well, some people might think it's semantics. No, these are legal reasoning in how things play out in a court of law. Okay, so now we fast forward this to Judge Kobayashi. So Judge Kobayashi was faced with the presumption. Our motion to reconsider clearly laid out the presumption rule as it applies to the court, because it's a rule of international law that we invoke pursuant to the U.S. Supreme Court Paquet Habana case of 1900 that says when a party has a right relying on international law, the court has to apply international law. So we put that on the record that the Hawaiian Kingdom exists. That's the presumption. So when Judge Kobayashi says the Hawaiian Kingdom doesn't exist without any evidence to rebut the presumption, the consequence of her stating that, not providing evidence of that, but just stating that, is an acknowledgement of the Hawaiian Kingdom's continued existence as a state. That's how the presumption applies, right? So it's like a defendant who is being prosecuted. That person is presumed innocent until proven guilty. What that means is the defendant does not have the burden to prove their innocence. Rather, the opposing party, in this case a prosecutor, has the burden to prove beyond a reasonable doubt that would rebut the presumption of innocence that that person is guilty. Without the evidence, that person is innocent. So by a prosecutor not providing any evidence that would rebut the presumption is at the same time admitting that the defendant is innocent. He doesn't have to say that. He just had the burden of providing evidence, without which the presumption of innocence remains. So that is how things played out in this court case. So when we say that Judge Kobayashi acknowledged the Hawaiian Kingdom's continued existence, was because she provided no evidence that would rebut the presumption, which she was fully aware of in our motion to reconsider. And that's important. So that is where things have changed now. What is also important is that in the State of Hawaii versus Lorenzo case, it even stated that when the United States admitted in its apology resolution that the overthrow of the government was illegal. Now, mind you, the apology resolution is just an American law, no different than the Statehood Act and the Joint Resolution of Annexation. It has no effect here. But the way the Intermediate Court of Appeals, Judge Heen, took that in his decision, he also stated that in light of the United States admitting to an illegal overthrow, it brings into question the very existence of the current government called the State of Hawaii. But nevertheless, the decision says, we're just looking at whether or not Lorenzo's attorney provided evidence that the Hawaiian Kingdom exists, because at that time, nobody applied international law. We applied international law, which that court stated in its decision that its rationale could be in question because of international law. We made that now part of the record in the federal lawsuit. And that's what makes this case profound, right? Meaning the case is about the continued existence of the Hawaiian Kingdom until an opposing party can say the Hawaiian Kingdom doesn't exist, but they can't just say it. We got to provide rebuttable evidence, without which the presumption remains, which means Kobayashi, by not rebutting the presumption, acknowledged the Hawaiian Kingdom still exists.
Okay, I have another question coming in, and this question is from Paul Lonokapu. Paul referred to Dexter's reading of that statement that you made from the Supreme Court Justice on the Hawaiian Kingdom, that if the court errs and the staff errs and so forth, that it's up to them to correct that error. So his question is, what happens in cases where, in previous cases where the courts ruled against a Hawaiian Kingdom subject, in the last 15 years? Does the court go back and correct those errors should this case flip everything over? Will they go back and reverse the decisions that were made previously? And if they do, what's the process?
So I guess I would say there's a number of caveats to that. One, it depending on how long ago the decision was, whether and again, first we're setting out in context that at some point we believe we can persuade these courts to transform itself into Article 2 courts because it's its obligation, right, under international law. And I guess your question is, once that happens, when the transformation to Article 2 courts have been accomplished, what happens to those prior decisions? I believe that's your question, right? Can someone then
Correct.
go back and have those decisions again altered or amended to reflect the transformation into Article 2 courts and the administration of Hawaiian Kingdom law, correct?
Correct.
So again, the limitations are, of course, how old is the case and when those cases happen, and if someone has either legal counsel to bring a motion to set aside or vacate the judgments. So those are just, but assuming they do, then, and depending on the time limitations, I think it's always possible that many of those cases can, again, be reviewed and overturned or set aside the judgments.
You know, Dex, maybe I can add to that.
Okay.
Okay, so let's just look at the federal court and any past decisions made by this federal court or the other federal courts in the District of Hawaii, right? So any decision made by a court that does not have jurisdiction, automatically all decisions are void. Okay? It's what is called extrajudicial, meaning it's outside of the capacity of the court to make a decision. So that means what we were presenting as evidence, because the Hawaiian Kingdom continues to exist and nobody has rebutted that presumption, all decisions made by the federal court in Honolulu since 1959, that is when the federal court turned into an Article 3 court. Prior to that, it was called an Article 4 court, where Congress created a federal court for territories of the United States. And that goes back to 1900. But in 1959, because we have shown beyond a reasonable doubt that there is a presumption of the Hawaiian Kingdom's existence, that would render every decision made by the federal court, not just Judge Kobayashi, any court, any judge since 1959, null and void. Now that can blow things up, and we knew that. But it is a fact, and it is the law. That's how it works. Now, the Council of Regency, our function is not to get personal over things. Our function is to provide, first, to expose, responsibly expose and educate, but also to provide a transition from illegality to legality, as recognized under international law. So a proclamation was done by the Council of Regency, which Dexter is a part of. He's one of the 4 officers, where provisional laws were proclaimed, which basically stated that in order to assist in the transition of over 100 years of non-compliance to the law of occupation of administering Hawaiian Kingdom law, all laws today will be considered, which would include court decisions, would be considered valid so long as these laws or administrative decisions or court decisions do not run contrary to Hawaiian Kingdom law. Okay, so an example of that would be human trafficking, right? That's a federal issue. Okay, so let's say that a decision was made on human trafficking where a defendant was found guilty. Evidence showed they were trafficking humans. Well, under Hawaiian law, there's no such thing as human trafficking. That is a law that was made in the 20th century, right? But this proclamation allows that to continue because that law on human trafficking would not run contrary to Hawaiian Kingdom law because the Hawaiian legislature would have passed a law similar to that. right? So the proclamation of the Council of Regency of provisional laws would allow certain cases, it has to be case by case. If they don't run contrary to Hawaiian Kingdom law, then those decisions remain. Now, the amicus brief that was drafted by the International Association of Democratic Lawyers, the National Lawyers Guild, and the Water Protectors Legal Collective, these three legal organizations drafted the amicus brief explaining why the court has to transform itself into an Article 2 court. And in that brief, they specifically brought up the 2014 proclamation of the Council of Regency that would allow, once the court transforms itself into an Article 2 court, then all the past decisions done by a court that was not an Article 2 court would remain and be valid so long as those particular cases do not run contrary to Hawaiian Kingdom law. So that's what is important as well. The Council of Regency, its purpose is to provide a transition as well as to ensure the compliance of the law. Because we have to bridge from where we are now after over a century of being brainwashed into believing something that's not true to 1893 and the laws that actually existed. How do you bridge that? And that's what the Council of Regency is doing. And that was acknowledged by the International Association of Democratic Lawyers, the National Lawyers Guild, and the Water Protectors Legal Collective, because amicus briefs that are drafted by people who are called friends of the court, right? The parties themselves, in the case of the Hawaiian Kingdom, although they support the Hawaiian Kingdom, as they stated in our position that this court must be an Article 2 court, we cannot participate in the drafting of any amicus done, right? That would be a violation of some major rules on the amici, and the ability for them to be purely a friend of the court and not disguising itself as a friend of the court by working with one of the parties, in the case the Hawaiian Kingdom. So for these three organizations to see that and to put that into the amicus to relieve the court of any anxiety it might have, not might, I'm sure it does, that all past decisions are void, there is that transitional means by which to bridge. And that's why this federal lawsuit, for 11 months, these matters have been in the pleadings, addressing some very hard issues that are consequential to the fact that the court is not an Article 2 court. So we have to keep that in mind, the Council of Regency. It's not trying to set up Judge Kobayashi. No, this is trying to provide Judge Kobayashi to provide a fair and regular trial, which would then allow us to get our relief that we are seeking in our complaint, but the court has to be an Article 2 court.
Okay, so the next question is that in the explanation that you just gave, as far as the courts, once they agreed to Article 2 court and so forth, and the declaration that was made by the Council of Regency that as long as they're in compliance with Hawaiian Kingdom law, that all past decisions will be valid. What about cases where it was brought up by Hawaiian Kingdom subjects that the court that they were in was an unfair court, and they used issues in regards to that and brought up Hawaiian Kingdom issues and arguments saying that it was an unfair trial and using whatever international law was, but yet the court still ignored that and at the same time ruled against them. Do those cases apply in that description that you gave?
Okay, so let me now get to state of Hawaii courts, because what I shared here was the federal court as the example,
okay.
Right? So state of Hawaii court. Now, myself and Dexter, and I can attest for Dexter, we're not going to speak to people making claims in a court that we weren't a part of, right? So many people, especially sovereignty activists, have been making claims that are not accurate, right? So we're not advocating for people to do that, nor agreeing with what was done. But I can address the issue of the state of Hawaii courts as a result of this federal case. The state of Hawaii defaulted, okay? Because the state of Hawaii defaulted and the clerk certified the default and filed it, that is profound, because the state of Hawaii, by not answering the complaint, which they've been given a few extensions of time to answer the complaint. So Dexter was in communication with the Deputy Attorney General procedurally on granting permission to the state of Hawaii additional time to file an answer. Because they did not file an answer within the agreed upon time after several extensions, the significance of that is this: by the state of Hawaii not answering the complaint, they are, as a result, acknowledging that what was stated in the complaint against the state of Hawaii is true. They're not denying it. It's true, right? And by being in default, they are not part of this federal lawsuit. They cannot enter to say anything. That train has left the station unless they can ask the court to set aside default so it can get back into the station and board the train. But the court can't do that until it's an Article 2 court. Up to this point, the state of Hawaii just admitted that everything the Hawaiian Kingdom stated in its complaint, by the mere fact that they didn't answer it, from a procedural standpoint, they're not part of these proceedings. So as the state of Hawaii is in default now, and that's why it was important in this notice of appeal that we are preserving the records, right? The records of statements made by the defendant or defendants, statements made by the court that works in our favor. We had to preserve that. That's why this case is still moving. It's very important. So you're looking at now, the state courts, they're all illegal. And the state of Hawaii acknowledged that because they provided no rebuttable evidence to the Hawaiian Kingdom's existence, which was the basis of this federal lawsuit. So when you now are dealing with courts in this way, it presents itself, or it presents opportunities that can be made before the court to address. Like this court is not lawful because it's not an Article 2 court, bringing in State v. Lorenzo with the presumption of continuity. And if they continue to deny a person of a fair and regular trial in a court that doesn't even exist, but it does act like it exists, it does issue orders to either put someone in prison or to seize properties, right, or to collect fines. That's all extrajudicial, and that would be stemming from a court that is not what is called properly constituted. And we covered this term, what is properly constituted or regularly constituted court? That means in international humanitarian law, called the law of occupation, courts in occupied territories have to be lawfully constituted. If not, and they do then continue to issue decisions, those are extrajudicial acts that would come under the war crime of depriving a protected person of a fair and regular trial. But these cases are individual because you have to take a look at whether or not the individual or individuals who committed the crime of depriving a protected person of a fair and regular trial actually had the mens rea, the awareness that what they were doing was wrong. And that is the flip side to making the record that the Hawaiian Kingdom continues to exist and that these are war crimes, thus placing the onus upon the opposing side to rebut it. Otherwise, that information could be used on the record against those individuals for possible prosecution in the future. And there are no statute of limitations for war crimes. So these are very serious issues. And the Council of Regency is not trying to prosecute anybody for war crimes. We're making people aware that this is the information with regard to this as a consequence of the Hawaiian Kingdom's continued existence and the failure on the part of the United States and the state of Hawaii to comply with international law. As a result, war crimes are happening. It's not just an unfair trial. It's unlawful appropriation of property. It's depriving a protected person of a fair and regular trial. It's pillaging, right? It's destruction of property. They're all different war crimes that happen as a result. Yeah, so that is the state of Hawaii courts. But again, I want to draw attention on the federal case and what this does, because the federal case has triggered so many things that have taken place on the record that we needed to preserve it. And that was in that notice of appeal. Dexter, you have anything else to add? I know we're coming to a close.
Yeah, I just want to say thank you. I mean, actually, I had forgotten about the
Billy,
council
I know you have.
proclamation, and that's an important part. But one thing I might just add as far as the Council of Regency's proclamation, though, at this point, none of the occupying forces, that being the United States, the judicial system, has begun to administer Hawaiian Kingdom law. So perhaps while the Council of Regency's proclamation is in place to provide those safeguards, it's not yet, how would I say, it has not yet been activated. Would that be a correct assessment?
Yeah, because what you have in an occupied territory is that of the occupier and that of the occupied. And they actually work together, but the responsibility for administering the laws of the occupied state is on the occupier, not the occupied. Okay. So a proclamation, we have authority to do that, right? That there is no doubt there. And a legal opinion has been drafted by Professor Federico Lanzarini on this issue regarding international humanitarian law on occupied governments, not occupying governments, but occupied governments. So we do have that ability to legislate by proclamation, to bring to ensure compliance, but also to provide transition. But if the occupier does not carry it into effect, it has no effectiveness, right? I mean, that's the whole point of why occupation relies on effective control and not just saying this is the law. You have to implement it. And that is also part of what is this complaint about. That's why we need the order to get the state of Hawaii and counties to transform itself into an occupying government in order to begin to effectually administer the laws, which would include the provisional laws, the proclamation. Right?
Billy? You're muted.
I keep thinking about how the rule of law is being thrown out the door, and wondering why the judge and all these cases, really the rule of law is not being there. And if we as individual citizens can't count on the rule of law, even in the court systems, I mean, I keep thinking in my head, what do we do next? Because you guys are in the fight doing these things in the court systems, but what does the everyday Kanaka do, or everyday protected person in occupied Hawaii do if the rule of law is being thrown out the door? And I know America believes in the rule of law, and I think a lot of international laws are based upon that as well. And so just thinking about that for us, I mean, it's really kind of a catch-22. It feels like we got to hurry up and wait to figure out if the court's going to follow their own laws or the rule of law in general.
Well, if I can answer that quickly, the issue of the rule of law, because of Hawaii's occupation, has only come about because of the Council of the Regency after it returned from the Netherlands in bringing awareness as to Hawaii as a country. And then from the year 2001 until today, I can say that things have definitely changed on a fast track as opposed to what it was. But remember, we're dealing with over 100 years of brainwashing that people were led to believe something that's not true. But our grand strategy, and I like to draw this attention to Donovan Preza, and it's in the latest blog article. And it's called Reaping the Fruits of Labor, right? The Hawaiian Council of Regency. And Donovan which I really like what he said because I had nothing to do with it. This was Donovan explaining it. He said, everybody's looking at Hawaii and our situation like it's a boxing ring, and that the Council of Regency is on one side and the United States is on the other. And everybody wants to see a knockout punch. Yeah, they want to see a knockout punch. But he says, if you've been watching carefully the Council of Regency, step by step, increment by increment, they've been making the ring smaller, forcing the United States to answer a question. And that question is not whether or not the Hawaiian Kingdom exists. That question is whether or not the Hawaiian Kingdom doesn't exist. And then he said it keeps getting smaller and smaller and smaller. The significance of Judge Kobayashi's statement, which is in a legal proceeding, it's not outside. The rule of law still applies. Hawaiian Kingdom delivered the knockout punch. She did not provide any evidence that the Hawaiian Kingdom does not exist. None, which means it exists. Now that positioning of the question was very strategic and tactical with regard to State of Hawaii versus Lorenzo, that the court even cited. And that we boxed the opposing party in the corner with the presumption of continuity as a matter of rule of law. So at no stage in these proceedings have we lost. This appeal does not mean we lost the case. No. This appeal basically verifies we're accurate. The judge just made a decision on not transforming into an Article 2 court. That is what is on appeal. Not that her statement that the Hawaiian Kingdom doesn't exist had any bearing. No. If anything, she acknowledged the Hawaiian Kingdom's existence. That's what she did. And in a court of law, you may have heard people say, don't say anything or don't write anything, because whatever you say or what you write can be used against you. It's best not to say anything. Well, for 11 months, nothing was said about the 800-pound gorilla called the Hawaiian Kingdom as a state. And Judge Kobayashi, in her two orders, decided to poke the gorilla. And that now caused the gorilla to respond and close the ring. And that is significant. So this case is not over. If anything, by preserving the record, we can now use that in other venues until an appellate court is able to hear it. Now, perchance, let's say the Ninth Circuit has to hear this appeal. Not that the Ninth Circuit has jurisdiction, but the Ninth Circuit procedurally has to hear the appeal. Well, the Ninth Circuit is going to be put in the same position as Judge Kobayashi. Before any appeal can be made or addressed, the court's jurisdiction is at the center. Because any decision made by the Ninth Circuit with regard to this case outside of the United States cannot have any validity unless the court can say the Hawaiian Kingdom, here's the evidence to rebut the presumption it doesn't exist, and therefore as an Article 3 court in San Francisco, we can rule on this decision and determine whether or not Judge Kobayashi made the right choice, right? So it is always the issue of the presumption of continuity. Because remember, the United States Ninth Circuit is in another country. We're in another country. And we have to understand that because we still need to understand how the rule of law applies between countries, not necessarily within countries, because we're outside of the United States and the Ninth Circuit is outside of the Hawaiian Kingdom. But the District Court of Hawaii is in the Hawaiian Kingdom, not in the United States. And this is a very profound time in our history where legal maneuvering that is based on evidence and law is at the center. And that's really what this is doing. Once it transforms into an Article 2 court, it's a domino effect, right? But Council of Regency has to ensure that the dominoes don't fall all over the place and destroy our economy, destroy how we live, that there has to be a transition to confine the dominoes to fall a particular way and not just fall away and just crash. No, we have to take our time. And that's why this is a grand strategy of the Council of Regency to ensure compliance through the exposure phase. Phase 2, that's where we are, exposure. To get compliance is the key. Compliance, not whether or not we exist. No, we exist. Presumption. Plus, the Permanent Court of Arbitration already acknowledged it. We don't need another judge to say the same thing. We just need you to transform into an Article 2 court. Unless you found rebuttable evidence that the Permanent Court of Arbitration missed, like a treaty. Yeah.
Okay, I got a final question for Dexter. And this comes from Keiko. Please define juridical. You mentioned that several times, and everybody's asking questions. What is juridical?
Oh, you're on mute.
You're on mute. You're on mute.
Kalamai, excuse me. So we did file motions for the court to take judicial notice, and that was explaining what, and in that case, and Keanu, correct me if I'm wrong, that was explaining why the rest of the world, or most of the rest of the world, operates under a civil law system. And in the civil law system, once an act is considered, once there is a juridical act, and in this case is the acknowledgement of the Hawaiian Kingdom as of a independent and sovereign state, then that is the juridical act, is acknowledgement of the existence of the Hawaiian Kingdom as a sovereign and independent state. And then what flows from that juridical act, excuse me, I may have it reversed, sorry, the juridical fact of the existence of the Hawaiian Kingdom. And then what flows from that is the consequences or the juridical act, which is, in this case, with the United States, its obligation to administer the Hawaiian Kingdom laws in the Hawaiian territory. So I believe that is what I was talking about when I spoke about juridical act. Now, in the motion itself, we also provided the expert opinion of Dr. Federico Lenzarini, who discusses juridical act and juridical facts, as well as the, I believe Dr. Sai has also commented, or is part of our motion, supporting or asserting why the United States has to comply or has to take judicial notice of the juridical act of the existence of the Hawaiian Kingdom. Sorry, I got that reversed again. The juridical fact of the acknowledgement and existence of the Hawaiian Kingdom, and the juridical act of the consequences which flow from that.
You know what I can do, Dex, is I can give some background of the juridical fact and the juridical act, right? Because I have to admit, I didn't know what a juridical fact was. So I can give some history of that and how it came to play in these proceedings. So Professor Federico Lenzarini is a deputy head of the Royal Commission of Inquiry. I'm the head of the Royal Commission of Inquiry. And in one of the preliminary reports, right, that was done, Professor Federico Lenzarini recommended inserting certain texts that the existence of the Hawaiian Kingdom as an independent state is a juridical fact. Now, the word juridical is Latin for legal fact, right? So I had no reason to question Professor Federico Lenzarini, right? But it came to mind, a friend of mine mentioned that same thing. And I knew when he said it, he didn't understand it, and he was an attorney, right? Not you, Dexter, right? So that got me going, wait a minute, what is a juridical fact? So I began to look it up, and I couldn't find anywhere in American jurisprudence of this term juridical fact. I did find it in civil law systems, the juridical fact, a legal fact. And that's when I started to do some research at the university, going through law journal articles to try to get a better understanding of civil law, okay, as opposed to common law. Common law are rules of the court that stem from Great Britain, the United States. So basically, any country that has a jury trial is a common law country. Countries that don't have juries are called civil law countries. And civil law countries are the European countries. Great Britain is the only European country that is common law, right? That has juries. In continental Europe, these countries there, and a lot of their former colonies who became independent states, which number over 150 countries today, are all civil law countries, meaning they don't have jury trials. The significance of that I began to realize is when you're talking about facts in the common law system, when you're dealing with juries, facts are determined by a jury. Law is determined by the court. Now, the court can determine facts if it's not a jury trial and the parties agree the judge is going to be replacing the jury. So in the American system, even in the Hawaiian Kingdom as a jury system is a common law system, not civil law, but it draws from the civil law as far as experience. And it said that in the civil law system, a juridical fact is a legal fact that the judge recognizes, which would trigger a juridical act, a legal act, right? Because not all facts trigger something. Facts are just facts, right? And the jury will determine the veracity of these facts, but the judge would apply the law. But in civil law systems, the judge has to look at facts and determine what is juridical or legal and what is not juridical or not legal, which would not create a consequence, right? So give you an example. In a house, well, let's say in a classroom, you have all these chairs in the classroom. Each chair is a fact, but one of those chairs is a juridical fact, a legal fact. That's called a throne, and only the crown can sit on it. And if someone sits on that chair that is not the crown, it has a legal consequence, whether trespassing, right, or something else. I don't know. I'm just using this as an example. That is a situation where not all facts are legal, but one of them are. One of them is, and it would trigger a juridical act, and that juridical act would be somebody's going to get arrested, right, or whatever the law says if somebody sits on a chair without permission. So the Hawaiian Kingdom is a juridical fact, meaning it is a juridical fact that it exists, and the Permanent Court of Arbitration, by understanding that juridical fact, knows that it has a legal consequence. And that legal consequence would trigger the Permanent Court of Arbitration to accept the dispute between a state and a private entity and then create a tribunal. So when I'm looking at this, I'm like, okay, well, I think I got it, but I got to speak to Professor Federico because Italy is a civil law system, not common law. So I presented my information to Federico, and I asked him, am I there with my understanding of what is a juridical fact that you used in one of our preliminary reports? And he said, precisely. And then he gave me the legal reasoning from the civil law system. I went, that explains why the Permanent Court of Arbitration did what they did. We couldn't explain the action taken by the Permanent Court using American rules of evidence or even Hawaiian Kingdom rules of evidence. But in the Hawaiian Kingdom court case, there is a court case that specifically stated, and we cited this in our request for judicial notice of the juridical act taken by the court with regard to the juridical fact. There was a court case in the kingdom that says when the rules of evidence are silent, the courts of the Hawaiian Kingdom can reach out to other common law countries or even civil law countries to use their reasoning in explaining things. So we were well within our limits under Hawaiian constitutional law and case law to utilize civil law in explaining the action taken by the Permanent Court of Arbitration with regard to the Hawaiian Kingdom as a juridical fact, a legal fact that triggered the juridical act of forming the tribunal, meaning they accepted the dispute. And that that was important. But Professor Federico Lenzerini was able then to draft a legal opinion that explains what happened at the Permanent Court of Arbitration through the lens of civil law, which he is very proficient at, and that's his expertise, especially coming from a country that is civil law. Now, mind you, when you look at the Permanent Court of Arbitration, when it was in 1907, when they signed that treaty that superseded the 1899 convention that formed the court, they basically were 22 countries that signed it. 2 of those countries that signed that treaty that formed the court, only the United States and Great Britain were common law countries. The other 40 countries were all civil law countries. That means they understood that when the Secretary General determines whether or not a state is a non-contracting party, that is considered a juridical act if he does acknowledge that they are a non-contracting state, because they have to be a state to begin with in order to trigger the Permanent Court of Arbitration to create the tribunal. We fell in that same situation under Article 47 of the 1907 Hague Convention on the Pacific Settlement of International Disputes. So yeah, this idea of juridical fact, juridical act, it's very new for us today, but we had the privilege of having Professor Federico Lenzerini, who is that expert, to explain it to the court. So the only reason why Judge Kobayashi said, I'm not taking judicial notice, wasn't because Professor Federico Lenzerini's opinion was flawed. She said, well, the federal court here already said the kingdom doesn't exist, so I don't have to do that, right? And again, she didn't rebut the presumption. So at the same time, she simultaneously acknowledged the Hawaiian kingdom exists. And that is important.
Okay. All right. Well, we're getting to that point, and our hour just flew by very quickly. And so, final thoughts from the Attorney General, Acting Attorney General Dexter Kaʻiama, and Dr. Keanu.
Thank you for having us this evening. So I guess I would just let you know that of course the appeal is pending, and we do have some obligations that we need to meet in order to continue to pursue the appeal and press forward with our demands that the appellate court transform itself into a competent court of jurisdiction, that being an Article 2 court. So, and I guess we'll keep you posted on that as it goes forward.
Well, we'll just have to continue on a whole series on this stuff. Dr. Sai?
Well, I think it's important for everybody who is in the audience. You're probably hearing a lot of these Latin terms, legal jargon, rules of law. We're not trying to dummy it down. We're just trying to explain it better. For myself as a political scientist, this is my background. Dexter is an attorney that understands and knows full well the procedural side of certain issues. We complement each other in the Council of Regency, and that's what's important. So when I do speak to these issues, this is really because of my expertise, not that I'm trying to speak to every issue that I can. Trust me, I don't know everything. But I do know these things, and I'm glad that the audience that you folks have here are giving Dexter and I an opportunity to explain things that when people read, let's say, the latest blog article on what is going on with the court, hopefully what we've been able to do is to provide some background, the substance, the reasoning, the rationale behind what was written. And it really is addressing this denationalization, because as all of us are recovering our national consciousness in our minds, we need to be fully aware of these issues, because our ancestors also knew these very same things in English, not just Hawaiian, in English. And that's important, right? And I want to say that in the Hawaiian Kingdom, the majority of the attorneys in the Hawaiian Kingdom were all Kanaka, and they were very proficient. Very well-known attorneys in the Hawaiian Kingdom included Joseph Navahi, James Kaulia, very important, right? But it also included statesmen who understood government, like Pilipo, right? Uh, John Cummins, okay? He was part native. He served on the cabinets of Kalakaua and Lilipo Kalani. They were all part of the Hawaiian Patriotic League. And why I bring that up with the Hawaiian Patriotic League, because their constitution that formed the organization after the overthrow of our government said that they will address these issues of maintaining Hawaii's independence or autonomy through peaceful means. I believe in that. Peaceful means. And that is what drives us to do what we're doing, but we have to keep educating our people. And that's why we not only teach it at the university level, but also, like in instances here, share it with the community at large. So mahalo for you folks for putting this on, Keli'i and Kali.
Well, mahalo to both of you, Dex and Keanu, for joining us. I really appreciate all your mana'o and explanation tonight. This is great. This is great. Mahalo.
Aloha.
Keli'i?
I guess the last thing is the kahea, call out to the viewers. If you are a skeptic or if you are still trying to understand information, I would challenge you to find that rebuttable evidence that says the Hawaiian Kingdom does not exist, and hopefully in doing your research there, you'll find what a lot of us found is that it doesn't, that evidence, I haven't been able to find it either. So I think that's a big part of tonight's presentation is really, it's no longer in our kuleana to prove that we don't exist. It's in the United States kuleana to prove that we don't exist, and we are here. We're evidence of existing, And so again, if you're a skeptic or if you're kind of like on the, what is this? Let me see what it is. I would challenge you to go and find it. Find that treaty of annexation. Find that information that says that the Hawaiian Kingdom does not exist for yourself. And then when you don't, come back and see us. All right. So other than that, mahalo for watching the show. See you guys next week.
And for those of you who are tuning in, and even if you're getting watching this on a delayed broadcast, it is very important that all of us begin to start learning and educating ourselves on all of these issues, because there's information out there. There's Dr. Sai's blog, hawaiiankingdom.org/blog, and it's been flashing all night long on the bottom. Go to that blog and start reading up. And if you have questions, okay, put questions in the blog, or you can contact me via email, kgumapack@gmail.com, and I will try to get answers for you. But don't stop learning. The more we learn, the more information we are able to get, the stronger our country becomes. Because our country is made up of us. And we need to be educated in the things today, without being blinded by it. Okay? And take the bull by the horn, order the book, U'Maukea, the best history book that's been put out ever, by Dr. Sai, and get onto the blog. And if you have any questions, feel free to contact us. I'd like to thank all of you for joining us tonight, and I hope you join us next week, because we're going to have Donovan Preza, who's a professor at Kapi'olani Community College, and this will also be a hanaho for him, because we're going to be talking more about land titles and land issues that affect all of us today as a result of what happened yesterday. Okay, mahalo going out to Lynn. Awesome job, and I'll hope to see all of you next week. Ahui ho.
Uama ke ao kaina I ka pono o Hawaiian Uama pono